Okay. All right, so thanks for coming. My name is Kevin Caradad. I'm the CEO of Cognitive Behavior Institute, and been in practice for the since 2014 at the Cognitive Behavior Institute. We've grown from by myself to about, I think with clinicians, we're definitely close to 45, with staff about 55. And part of what we're now pivoting to do is give back to the community through two ways. One is through doing research. Others are by making referrals, as well as our Center of Education, which is putting this on tonight. And our Center of Education, along with our nonprofit, is going to look to produce no-cost or low-cost trainings moving forward, and that will grow and get more robust from kind of like how do you start your private practice to actual trainings in modalities, including certifications down the road. We also provide psychotherapy, psychological testing, and psychiatry here. If you happen to refer to us, we don't mandate clients to see our therapist, and we also refer to you also. The reason why I brought Daniel Lynch, who's a lawyer here and has several different offices to which he'll speak to, he did some lawyer work for us early on when we set up the Cognitive Behavior Institute. And I think part of our success is related to having the policies and procedures. Just for those that are online, if you could mute your side, I think we may be getting just a little bit of feedback. I'd appreciate it. All right, thank you. And it was instrumental, I think, into the success over time. When you have a good policy and procedures on the human service side, as well as on the business side, having a structure and having the proper setup, it kind of guides your decision-making so that you're successful and so that you don't get into your private practice down the road and you kind of say, oops, and you've missed some things. And so part of what we're trying to do is give back to let everybody know what we've learned so you don't make the same mistakes. And so that said, I'm going to pass it off to Dan Lynch, who's been very helpful to us, and I hope he is as helpful to you in the knowledge you learned today, as well as the additional series we'll be putting on once a month. We'll be putting on 2 more this month, and then we'll kick it back off in 2020. So Dan, why don't you introduce yourself to everybody about yourself and start right. Thank you.
Excellent.
Thanks.
Thanks for having me, Kevin. Thank you for attending this evening. As Kevin said, my name is Dan Lynch. I am the managing partner of a law firm with an office here in Cranberry Township, Pennsylvania, as well as South Point, and we have an office in Bridgeport, Connecticut. I started the business almost 18 years ago. And we've now grown to 20 lawyers and I think about 16 or 17 support staff. And our practice focuses on businesses, small to middle market companies, privately owned. We do day-to-day contracts, incorporations, customer contracts, vendor contracts, mergers and acquisitions. We help clients buy and sell companies. We have a couple of employment lawyers. So if you're thinking about things like non-compete agreements or non-solicitations, as you build your practice, that's probably something that you need to talk to a lawyer about. We've got a real estate department. We have 3 patent lawyers, and we have a pretty robust estate planning group. We have a family law lawyer, and of course litigation. We do commercial litigation. Hopefully you never meet those guys. Trial attorneys. Where the corporate group and the estate planning group come together is something called business succession planning, because you can't really talk to a business owner about his succession plan without talking to him and her about their estate plan. And you can't talk to a business owner about their estate plan without talking to them about their business succession plan. So I end up doing a lot of that kind of work for my business clients. Tonight, we're here to talk about corporations, limited liability companies. What's it mean to be a subchapter S corporation? So part of the deal that you get when you hire a lawyer, I view my role as one of an educator, right? I teach my clients what they need to know about the legal aspects of what they're getting themselves into. And anybody can form a corporation on LegalZoom. But what you don't get is you don't get a lawyer on the other end of the phone who can field questions, who's going to teach you things, who's going to talk to you about how to use that corporation to your advantage. So before you set about to set up your own corporation, you might consider having a relationship with a lawyer, because having somebody on your side when it comes to just any weird kind of legal or quasi-legal business issues is an important part of your success. We're here tonight to talk about, as I said, LLCs and corporations. An LLC, or a limited liability company, is a newer, relatively newer construct by the legislature. LLCs have been around for about 30 years. Traditionally, businesses have set up as corporations. Now, there are two main reasons why you would want to incorporate. You incorporate to save money on taxes, and you incorporate to protect your personal assets. And I'll explain those as we get into this. When you form a corporation in the corporate world, you file what's called articles of incorporation. You also have to create bylaws, and bylaws are the governing document, how you run the corporation. In an LLC, to form an LLC, you file what's called a certificate of organization. So in LLC world, there are analogous documents and filings that you're required to do, like you have with a corporation. So in LLC world, you've got certificate of organization and then an operating agreement. Your operating agreement is essentially bylaws in the corporate world. Both types of entities we do, we draft organizational meeting minutes that create and empower and breathe life into the corporation or the LLC. There's a docketing statement that's required to be filed for both with the Corporations Bureau of the Secretary of State's office. And then part of that process also requires getting a tax identification number, or some people refer to them as employer identification numbers. We do that for you as well. The difference between an LLC and a corporation are very stark. A corporation that you form is no different than any other corporation that you deal with, even in the public sector. Publicly traded companies, they're formed the exact same way. So Apple and Google and Microsoft and all those corporations that you think of as these gigantic corporations started the exact same way, by filing articles of incorporation and having bylaws. So corporations are sort of clunky and hard to manage. You are required to have an annual meeting of the shareholders. You're required to have an annual meeting, at least once a year, meeting of the board of directors. The legislature 30 years ago or so decided to try to make it easier for people to incorporate and manage a business with the protection of a corporate veil. And so they created this entity called an LLC, limited liability company. You're not required to have meetings, although we'll talk about governance here in a second. And there is no board of directors. In an LLC, what you own is called units or interests. That's analogous to, in the corporate world, stock. In a corporation, there's two levels of tax. The corporation pays tax at the corporate level, so any profits that are made, and then when you pay yourself through the corporation, you're going to pay an individual tax. So years ago, they decided to make it a little more palatable for small businesses to do business and not pay a double tax. And there's a reg in the Internal Revenue Code called Subchapter S. And what Subchapter S does is it creates a pass-through entity. It makes that corporation a pass-through. And what we mean when we say pass-through, it means that there is no tax at the corporate level. All the income flows to the owners, and you just pay your individual income tax. An LLC is a pass-through entity. There is no corporate tax for an LLC. Now, what's interesting is you are allowed to make an S election even though you're an LLC. So when you make an S election or become a Subchapter S corporation, and I can't emphasize enough, a Subchapter S corporation isn't a special type of corporation. It's still a regular old corporation, but you've elected to be taxed as an S or under Subchapter S, and you get the benefit of pass-through taxes. For an LLC, the legislature created this this thing, right, called an LLC. It's a legal fiction, but an LLC, just like a corporation, is a living, breathing thing. And I guess some of the other distinct characteristics of an LLC are you can only have, of a Subchapter S corporation, it's limited. You're not allowed to have any foreigners as a shareholder. You have to have less than 100 shareholders. You can't have a trust. Special types of trusts be owners. So you have to be careful about that. And so because of those limiting features, and because of the clunkiness of having certain formalities, the legislature said, hey, let's make this easier for people, and they created LLCs. Depending on, before you decide whether you want to form a Subchapter S corporation or an LLC, you should think about what is your exit, whether you're going to take on partners or not, other equity owners. That'll dictate what you decide to choose. Even though an LLC is not required to have annual meetings of the members, it's still a good idea, because what has happened over the years, let me back up a step. There are 4 ways to pierce the corporate veil, right? So remember, I said one of the reasons people incorporate is to protect their personal assets. So what happens there is you have this corporation and you have your personal assets over here, and there's a corporate veil, right? There's a shield that's protecting your personal assets. This is why the legislature created corporations in the first place, to encourage people to become entrepreneurs. As a sole proprietor, there's no corporation. You are fully exposed, right? Your personal assets are at risk of any malpractice claim or any other claim that results from your customers or clients. So you form a corporation to give you the benefit of this corporate veil. People are more likely to form a corporation and go into business knowing that their nest egg over here isn't at risk. However, there are ways that courts will allow a creditor to pierce that corporate veil and get at your corporate assets. One of them is using the corporation to perpetuate a fraud. I don't have any clients that do that, right? That's criminals and shady people. Another one is undercapitalization. Undercapitalization is where you take all of the money out of the corporation and put it over into your personal bank account, and then you leave your creditors swinging in the wind. That is not allowed. A court will pierce that corporate veil, get that money back from you. You've got to be able to pay your bills or file bankruptcy. The next way, the third element of piercing the corporate veil is commingling funds. So in other words, you don't keep good books. You're using your personal money to buy stuff for the corporation and not accounting for it, or you use corporate money to buy bread and milk for your home. Not allowed. right? Commingling Funds is a very easy way for a judge to sort of latch onto and say, yeah, you're not, we're not going to give you the benefit of the corporate veil. The fourth way that a creditor can pierce the corporate veil is by failing to engage in corporate governance. So what is corporate governance? Corporate governance is having your annual shareholder meeting, having your annual board of director meeting, passing resolutions that are at a significant level now, a high enough level that would warrant board approval, board of director approval. Not running the day-to-day business, okay, not buying pens and Post-it notes, but maybe buying a vehicle or entering into a lease or buying real estate, entering into a loan with a bank, doing a mortgage. Those kind of things, things that have to do with your qualified plans, so 401k, for example. Those things require board approval. And that's what you call corporate governance. Now, what happens is if you don't engage in corporate governance, right, then a judge is going to say, hey, you didn't treat this corporation as the living, breathing thing that it is. And because you didn't treat it as with the respect that it deserves, I'm not going to give you the benefit of that corporate veil, and I'm going to allow that creditor to pierce the corporate veil to get at your personal assets. So corporate governance is very important, and it is the number one reason or most popular reason that people get into trouble with their corporations, because it's kind of over there, right? It's on the side. You're busy with your practice, you're busy with your clients, you're busy with your families, and people say, yeah, I just never got around to it. I get calls all the time from clients or potential clients that say, hey, Dan, I haven't had a board meeting or a shareholder meeting in 20 years. What do we do? So we do what's called legal forensics and help them fix that and get them compliant. So if it's a small business, right, and there are only a couple of owners or one owner, you still, and in the corporate world, you still have to have your meetings. But the reason that the legislature requires meetings is what I refer to as the marketplace of ideas. They want people to have a dialogue. They want the directors to get together once a year to talk about issues and discuss and debate these resolutions that you're passing. If everybody agrees, there's nothing to debate. There's no discourse, right? There's nothing to talk about if we all agree that we're going to proceed in that way. And so what you're allowed to do is enter a resolution that, or avoid a meeting by entering minutes that say, it's called a unanimous written consent in lieu of an actual meeting. So unanimous, everybody agrees, we don't have to meet to talk about it. Here's the unanimous consent, everybody signs off on it, done. So for small businesses, that's an easy way, if you're in the corporate world, of managing those affairs. Even though LLCs aren't required to have annual meetings of the members, it's a good idea to do that, because what has happened over the last 30 years, because there's not a lot of common law is case law. Case law is what judges make decisions, right? And they write opinions. And the LLC statute is very thin, not a lot of guidance on what's required to engage in governance for an LLC. And so what the courts have done over the years is they draw on the case law that exists for corporations. Corporations have been around for hundreds of years. So there's lots of case law on what is governance and what's required and the minimum threshold of compliance. And so there are cases out there in Pennsylvania that talk about the fact that even though an LLC isn't required to have meetings, it still has to engage in governance. And so you need to document those things like you do for a corporation in your corporate minute book, so that if there is a situation where there's a creditor or a lawsuit, that your governance will give you the benefit of that corporate veil. Without the governance, without doing meetings, without the unanimous written consents, without certain activity that you record, the judge is going to say, hey, you didn't treat that LLC as that living, breathing thing that it is. You treated it as yourself. And the term of art is alter ego. You treated that corporation as your alter ego. I one time had a client say, damn, why do we have to get so particular about these minutes? I'm the LLC. The LLC is me. What's the difference? And, my hair caught on fire because no, you can't do that. You can't think of it like that. That's the alter ego theory. And that's what allows, or judges will latch onto that and say, hey, you treated that corporation as yourself, then you're not getting the benefit of the corporate veil. And I'm going to allow this creditor to pierce the corporate veil to get at your personal assets. Does anybody have any questions about what we've talked about so far? Okay. So let's do some questions now. Fire away.
Where do I start? How do these meetings go? Who initiates this? How is that even, how do you do that?
Yeah, so in the corporate world,
I think in private practice, you're probably going to have, right, most likely individuals that have a practice, or an individual LLC that'll have 2 or 3, and then maybe you'll have a group practice. Those are probably the populations that will hear this today.
Mm-hmm.
Yeah, I'm right now a sole proprietor.
Yeah, you don't want to do
and
that.
I don't see, I see myself being kind of small, like me, maybe somebody else down the road.
Mm-hmm.
So that's kind of the.
But it doesn't matter if you have somebody else down the road or not. You still want to incorporate because you need the benefit.
Right.
As you start to accumulate wealth, because your business is going to be successful, you need the benefit of that corporate veil to build your individual wealth. Okay. So to answer your question, in the corporate world, you elect somebody called the chairman of the board. And don't think that, if you look at IBM, for example, they've got 40 board members and a chairman of the board, and these board members are from all over the country, and they've got a president and a secretary, a treasurer, and probably 100 vice presidents or more, 1,000 vice presidents. When you set up your corporation, if you choose a corporation, you're required to have a board, a director, at least one. You could be it.
Okay.
In fact, 99.9% of the time, the owner, the proprietor, is going to be the director.
Okay. You're
required to have a president, a vice president, a secretary, and a treasurer. You can be all 4 of those things. Yes. Did I say vice president? You're not required to have a vice president. You're required to have a president and a secretary and a treasurer. You can be all 4. You can hold all 3 of those offices.
Okay.
So who initiates it? The owner, you, the majority shareholder. If you have partners, and I'm using that term loosely, co-owners, you're going to decide who's the president, and the president is required to manage that governance. In LLC world, remember, you're not called a shareholder or a director, you're called a member. You're a member of the LLC. And it's based on 100% interests. It always adds up to 100%. So you can be the 100% owner, or if you have a partner, you could be 50-50. I don't recommend that. Don't ever do that to yourself. Somebody always has to be able to break the tie. You don't want deadlock. So 51-49. So the majority member is the person who would be required to initiate a meeting or some resolutions or some aspect of control over governance.
And you just keep these minutes and then submit them to somewhere?
You get, I should have brought one. I didn't think of this, but we purchased they're called corporate minute books, and they're just 3-ring binders.
Oh, okay.
You don't happen to have any with your logo and contact on it we can hand out to people?
I know, that would be cool, wouldn't it? We should start doing that.
Write it down.
Yeah, write that down. Kevin's the idea guy. I like it.
Spend more time here.
So in LLC world, ask more questions.
I don't know.
Anybody else have any questions?
I do have more, but I'll
Please be muted.
Paul, if you have one, you can unmute, or the other individual with the 8307 phone number, if you have any questions, please.
Yes. If you don't have an LLC, but your personal assets are jointly held, doesn't that offer protection?
That's a great question, Paul. Thanks for asking it. That is one of the items that I was going to discuss.
If you could remute, that would be great, Paul. Thanks.
So Pennsylvania is one of 7 states in the whole country that says you can't use, or you can't be forced to use marital property to satisfy an individual debt. You got to be married, and it has to be in joint names. So a bank account in husband and wife's name has a pot of cash in it, and husband is in a car accident and he kills a few people, and his insurance isn't sufficient to pay those creditors, right? There's going to be a claim, and if his insurance isn't high enough to adequately compensate the victims of that accident, then they're going to look to his personal assets. What does he own? If he owns a bank account all by himself, that bank account's at risk. In Pennsylvania, if the husband's married and they own everything jointly, that joint bank account is not subject to a levy as a result of a judgment against a single person in the marriage. Now, what's important to remember about that is, you said that this might be all over the country. People from all over the country might be listening to this. You have to check on your particular state where you're located to see if you get that protection. It's nice that Pennsylvania does that. It's an archaic rule. They talk about moving away, abandoning it all the time, but they have yet to do that. So we do get the benefit of that. It's important that if you are married that you keep everything jointly, because you do get that level of protection. Whether you're in a car accident or whether there's a claim through your business. So in addition to the corporate veil, if you're married and you hold everything jointly, let's say that a judge does allow a creditor to pierce the corporate veil. If you own everything with a spouse, you're what we call judgment proof. They can't collect. Now, I'm going to go
Is that
one
your
level.
business account? You're talking about separate from
personal.
Okay.
Mm-hmm. Paul, does that answer your question?
Yes, it does. I appreciate it. Thank you.
Yeah. So in addition to that extra layer of protection, I'm going to get a little bit hyper technically legal on you right now. So tell me if I go too fast. But a lot of times husbands and wives will want to go into practice together. They'll want to form the corporation or the LLC together. And they say, we both want to be owners, unit owners, or shareholders of the corporation. And I go, no. Take advantage of this old archaic rule in Pennsylvania and only have one of the two be the owner. Because if husband and wife are both owners of the corporation and they pierce the corporate veil, what does that mean? Piercing the corporate veil means you get to the assets of the owners. You get to the assets of the individual owners. So if it's a husband and wife team and they're the owners and you're getting to their personal assets and husband and wife own everything jointly, all that stuff is fully exposed. Does that make sense?
The personal assets keep together, the business keeps separate.
That's exactly right. And so I tell people all the time, look, pick. It doesn't matter who's going to own the company. It could be the husband. It could be the wife. The other person can work there. They can be an employee. They can be an officer. They can be a president, a secretary, a treasurer. You give them any title you want, but don't let them be an owner. That's a good question, Paul. Thanks for bringing that up. What else?
Are there any tax benefits from one to the other or
Yeah.
different corporations?
Yeah, so remember I said one of the 2 reasons why people incorporate is to save money on taxes. When you make an S election, which if you're going to be a corporation, you should do because you want pass-through taxation. You don't want to pay 2 levels of tax. Subchapter S says that you are allowed to pay yourself reasonable compensation. That's the actual words in the code. Reasonable compensation. So reasonable compensation is something that is somewhat ambiguous. What's a reasonable compensation for an owner of a therapy practice or a psychology practice or a psychiatry practice? What's reasonable compensation? Pick that number. Maybe it's $60,000, maybe it's $80,000 a year, maybe it's $120,000 a year. But the point is, you'll pay tax on your reasonable compensation, but if your business makes more than that, the owners get that as a dividend. If you're in corporate world, it's called a dividend, just like your stock in Google pays a dividend. In LLC world, it's called a distribution. So you get those you pay, you don't pay what we call self-employment tax on dividends or on distributions. Put a little asterisk by that under distributions, and I'll come back to that in a second. The self-employment tax is for those of you that are employees, or when you were an employee, you remember you would get that pay stub and it would have all this withholding, FUTA, FICA, Medicare, Medicaid. It adds up to about 15.5% of tax. The employer pays half of it and the employee pays half of it. So if you're the owner of the business and you're paying yourself reasonable comp, you're going to pay self-employment tax on the amount that you pay yourself, but for the dividends that come out, you don't have to pay that self-employment tax. So you're able to save that 15.5% or so for all of the money that you put in your pocket that's in excess of your salary. So what people do is they argue that that reasonable comp for somebody in that is running a practice of that size is on the low end of what the market could bear, because they want to save that money on taxes. Now, in LLC world, if you make an S election, remember I said as an LLC, you can still be choose to be taxed as a partnership. That's what a subchapter S is, partnership tax, as opposed to being taxed as a corporation. And so you're allowed to do that, and you play the same game, if you will, of reasonable comp and take the rest out in a distribution. But if you're a professional, right, there's a list in the statute, and I'm certain that psychiatrists are in it. I don't know about psychologists or therapists. We can check on that for you. But there's a list of about 13 professionals, chiropractors, podiatrists. It's in there. I don't know why I remember that, but there's this list of professionals that have to pay self-employment tax on all their distributions, whether you're sub S or not.
My experience is, if I believe right, that excludes us psychotherapists.
Does it? It's easy enough to check.
I'm an S Corp, so I think I switched to it, I think.
Yeah, for the reason I'm talking about right now.
We're not included.
And if that's true, then that's
You can
good.
verify that for everybody, but I believe that's my accountant advised when I switched.
Any more questions?
How easy is it to switch between the two?
It's not.
It's not. Okay, so you got to figure it out.
Yeah.
Stick with it.
Either way, Dan can help you if you decide to do that.
That's true. And I tell clients all the time, I can make anything happen. It's just how much money do you want to throw at the problem, right? I ask clients, hey, tell me, what do you want to have happen? And I can make it happen with words. That's a lawyer's job. That's my job, right? That's what I do. There's something called recapture. So that would take this into a 300 level course, and we don't need to do that. But if you are an LLC and you want to switch to a corporation, there's recapture tax that they make you pay. And this is a look back of 10 years, and yeah, it's messy. Sometimes it makes economic sense, right? Sometimes the dollars make sense to do that. Most of the time it doesn't.
And I think it depends, and I'm not an accountant or a lawyer, so take it with that. I think if you're transitioning from one to the other during a year where there was no particular high revenue, so you're going from kind of single proprietor, lots of write-offs because of growth, and you pivot out of there, there's less of that to have to be.
Yeah, the smaller you are, the cheaper it is for sure.
Yeah.
But what I would recommend that you do is I'd say, you know what, let's just shut this business down and start a new one. Now, for insurance providers, right, if you do work and insurance companies pay, that's a pain because now you have a new tax identification number and those control numbers that you guys have to get with every contract, with every provider that you have. But if you're willing to go through that headache, then shut down the old corporation, start a new one, LLC or vice versa.
Any other questions from those online or via phone?
I have a question. I work for an LLC, and I have talked to other independent contractors. I didn't know if it would be worthwhile to form an LLC for myself just for protection, or if that is not really a concern.
Well, you're an employee, so
1099.
She's an independent contractor.
yeah, well, okay, so but you work for an LLC as an independent contractor. Here's what happens. If there is a claim, right, if you are advising somebody and you think about what your exposure is too. Your exposure, your risk is dictated by what you do. So think of some worst case scenario. You give somebody some advice and they go out and kill some people and they somehow connect it back to the advice that you provided. Then not only is your LLC going to get sued, but I think the individual, you as an individual, will also get sued. And if you're willing to take that risk, then there's no need for you to incorporate. But I would suggest that risk is probably not worth the small cost of incorporating and being in a single member LLC.
She would be protected.
If you're a single member LLC, and you're an LLC just like we've been talking about for the last 35 minutes or so, you will get those protections that I've talked about, but you still have to do governance. You still have to not commingle funds. You still have to be adequately capitalized, which won't be hard to do as a single member LLC. And the nice part about a single member LLC is it's what they refer to as a disregarded entity because there's only one owner, and it shows up on Schedule C of your 1040 tax return. If you're a multi-member LLC, then that LLC has to do its own tax return, even though there's nothing due, it's passed through, but the entity itself has to do a tax return. Corporations, even though you're a pass-through because you're going to be a subchapter S, has to do a tax return. So a single member, for those of you that are just thinking about, hey, I'm just going to be on my own, no, it's still really important to be to practice within that LLC to protect that wealth that you're going to accumulate over your career.
You mentioned the insurance, like billing. I don't know if this is in your area, but so if you transitioned into an LLC, you have to, and you get that tax ID is probably one of the first steps, right?
Mm-hmm. The lawyer does that.
So you have to wait for the insurance companies to process that information before you can start billing under that new tax ID, correct?
Yes.
Okay. So that would just kind of be sitting there until the contract.
Yeah, but it only takes a day to get a tax ID.
Yeah.
Yeah, we do them online now. It's
okay.
Okay, so we talked about the differences between an LLC and a corporation. Mm-hmm. We've talked about the tax benefits of a subchapter S election. We talked about the 4 ways of piercing the corporate veil. We've talked about how to protect personal assets and the benefit of being married. There's lots of benefits, don't get me wrong. But if you're in business, that's one of them. So what else? I'll open it up to I'll field any question that you happen to have. I shared with you at the beginning what all the different practice areas that we have. And so I'm involved in a lot of those practice areas and would be glad to answer any questions.
Dan will be back on the 14th talking about contracts, or someone from his office, contracts in private practice of November, 14th of November.
Yeah, I think, Mark?
We may have had Mark Sullivan slotted for that. Yeah, who's very, very good.
Okay.
You'll like him.
So any more questions? Fire away, now's your chance. Ask the lawyer.
Yeah, this is Paul again. I've had an EIN since 2002, really to help protect my Social Security number, and that's how I'm registered with all the insurance companies. That I don't have an LLC, but I don't necessarily have to have an LLC if I have an EIN.
No, you don't. You can be a sole proprietor and still have a tax identification number.
Do you have the same protections?
Nope. The tax identification number is just exactly what it is. It's an identifier. It's a numerical identifier. It's like a name. It does not give you any protection at all.
So just so I'm understanding the terms, right? You're referring to the S Corp and the subchapter S, those are the same things.
Yeah, a corporation is a corporation. And if you are going to be smaller than 100 owners, then you can elect under subchapter S of the Internal Revenue Code to be a pass-through entity. That's all that means. So it's still a corporation. It just has a special designation as a tax mechanism, and people just refer to it in the vernacular as an S Corp. I'm an S Corp. Well, no, you're a Corp with an S election.
Why would someone choose to be an S Corp versus an LLC?
It's really rare that we're doing S Corps. We do mostly LLCs now because they're so much more flexible. When you're taxed as when you're an S Corp, those profits that we talked about earlier, they have to be distributed proportionate to ownership interest. So if you are in practice with somebody and you're a 90% owner and they're a 10% owner, those profits get divided 90-10. Sometimes that's not always fair, right? That's not equitable. In an LLC, you don't have to do that. LLCs, you can share distributions.
So it sounds like, everything is very unique. And so part of which would be helpful for those considering and weighing that is probably talk to Dan in his office or one of his partners individually to kind of really understand your unique situation.
Yeah, it's, in the tech world, a lot of times people want to be corporations and then elect to be taxed as an S because venture capitalists don't like to invest in LLCs for the reason that I just discussed about how to share profits. Venture capitalists choose to or would prefer to invest in corporations. I think they think that there's it's easier to take that company public, right? LLCs can't go public. You have to be a corporation. So in tech world and in that type of business community, people prefer to be corporations. But short of that, there's really no reason why you would want to be a corporation. And as I said, with the S election, with all those constraints, it just makes so much more sense to be an LLC. Now, I'll tell you something else about that we do. It's not required under the statute, under the code that created LLCs. You're not required to have a president or a secretary or a treasurer. But I will tell you, and I've experienced this myself, the world isn't quite used to LLCs yet. It's still that new that people, when you go to a bank and say, I want to open up a bank account, and they're going to say, well, we need your president to sign this. Like, we don't have a president. I say, well, yeah, you do. Who's your president? You're a corporation, right? Well, no, I'm an LLC. Technically, my title is called member. I'm a member. No. You need to have a president. Who's your president? And so you get into these arguments with banks, insurance companies, maybe some of your providers about having officers. So like I said before, with words, I can fix that. And we do a resolution that even though you're an LLC, we do a resolution that appoints somebody as a president, somebody as treasurer, somebody as secretary, and as many vice presidents as you want. So we just fix it, and it saves that huge headache when you're dealing with the outside world that's not sophisticated enough to understand the differences that I just articulated, and you just sign as, you have the title. So even if you're a single member LLC, I still suggest that you ask us to, and I always explain this and then ask, who do you want to be president?
And they can pick themselves.
Yeah. Yeah.
What would be your advice if, like, to get started? How do I rephrase this? I'll just be blunt here. So I'm doing some things wrong already. I can tell just from the conversation that, like, for the bank account, I have a separate business account, but there are times where I run out of checks. So I use my personal account to pay the rent or, things like that. Mm-hmm. So I can't change what's happened in the past, but moving forward before is there anything I can do to prepare, I guess, to moving to the next step, or is it just like on day one of LLC?
No. Okay. Well, you're not an entity anyway. You're a sole proprietor. Right. So Commingling Funds doesn't matter for you.
Oh, okay.
There's no veil to protecting you, so there's no veil to pierce.
I gotcha.
You're fully exposed as it is.
Yeah.
So, but you ask a good question for your own purposes, even though you're a sole proprietor. But when you're a corporation or an LLC, it's simply a matter of accounting, right? So what happens is if you pay for something personal through your business, you just have to account for that in your QuickBooks file or your accounting software, and you say, okay, that was a distribution.
Okay.
So let's say you, I don't know, bought a computer and it ended up in your house. Well, that's not a proper expense for a corporation, and so instead of taking the expense of $1,000 for a computer, you call that a distribution to yourself, and you get taxed on that money. So, any more questions? Okay.
All right, great. I want to thank Dan and for coming and representing his law firm. We're going to be posting this online as well as with Dan's contact information hyperlinked to it, as well as we're going to have two more this coming year. We're going to have accounting for individual and group practice on the 17th of October, and then Dan's firm will be back here about in November 14th about contract and private practices, and we'll pick up with further seminars back in the beginning of 2020. You can check those out at our CBI Center for Education.com website to see all that. But I want to thank you again for coming and putting this on. It's very helpful, and I think
you're welcome. I'm glad to be here. I want to mention one last thing, and that is, I do not represent any of you. For those of you here in person, and for those of you that have dialed in, the rules of professional conduct governing lawyers' behavior in Pennsylvania are very specific about this. In order for me to be your lawyer, there's certain housekeeping things that we have to do, like execute an engagement letter. And I don't want any of you to think that I am your lawyer until we go through that process. So keep that in mind as you're setting about and taking action based on anything that we discussed today.
Yeah, and as you can hear, these things are very complicated. Went through a long process of growing the business and knowing how difficult it can be, and things you don't think about is what's going to happen. And so talking to Dan and coming to these other future seminars, you're going to learn from all the things that Dan has seen throughout his experience at his firm, as well as the things that we've experienced both with our accountant and ourselves that hopefully will prevent you from making those mistakes. So thanks for attending, and if you want, this will be posted online and you can review it again. Otherwise, thanks for attending, and we'll see you next time.
Thank you.